Mr. and Mrs. Smith are making their will. When asked what they would like to happen to the family home, they explain that they would like it to be passed equally to their children, Charlotte and Dexter. The advisor tells them that this may not be the best option and asks them to imagine that 30 years from now they pass away. And at that time, their daughter Charlotte is married, but she's separating from her husband. If she gets divorced, part of her share of the property could pass to her ex-spouse. Now, imagine that Charlotte and her husband don't get divorced. If Charlotte passes away first, her share will pass to her husband in its entirety. Is this what Mr. and Mrs. Smith would want? Or what if their son Dexter is struggling financially and, in contrast, Charlotte is successful and wealthy? Should the property still be split equally? It could be that in 30 years' time, either Charlotte or Dexter is suffering from an illness and need residential or social care. As a result, their inheritance could be used to pay for their care. Imagine that Charlotte or Dexter have an addiction to gambling, drugs or alcohol, or that one of them has financial problems. In this scenario, leaving them a share directly would certainly be unwise. Similarly, if one or both of the children become estranged, would Mr. and Mrs. Smith want them to benefit at all when they pass away? Finally, inheritance tax might be avoided or reduced where assets, in this case the family home, are passed on for the benefit of future generations. In any of these situations, a simple 50-50 split between Charlotte and Dexter might not be the most effective way to deal with the family home. Indeed, without a crystal ball, it's impossible to know what to do for the best. Similarly, many things could happen during Mr. and Mrs. Smith's lifetime that would prevent the property from passing to their children. As well as the unexpected, simply owning a property can create problems if you die. First of all, the costs of administering the estate on death are increased significantly where a property is involved. In addition to increased costs, Charlotte and Dexter might have to wait months for the property to be dealt with and for the courts to process the will and probate. These delays can lead to other problems. Mr. and Mrs. Smith ask if it would be better to transfer the property to Charlotte and Dexter now to avoid these problems. But what if Charlotte or Dexter get divorced, go bankrupt, pass away, or become estranged from their parents after they've been gifted the property? Mr. and Mrs. Smith could lose their home. So, what is the solution? How can Mr. and Mrs. Smith make sure the property passes to their children at the right time in light of changing future circumstances? One solution would be for Mr. and Mrs. Smith to transfer their property into a home protection trust. In this case, the property would no longer be owned by Mr. and Mrs. Smith, nor would it be owned by Charlotte and Dexter. It would be owned by the trust. Mr. and Mrs. Smith could live in the property until they die. They could even move house. In fact, for them, very little would change. So, the property can be kept in the family, even if Mr. or Mrs. Smith suffer health issues and need support, or Charlotte or Dexter go bankrupt or get divorced. The property would be protected from the time it goes into the trust and for the rest of Mr. and Mrs. Smith's lives, as well as their children's lives, or even their grandchildren's lives.